How many of you, instead of a will, have a living trust? How many of you have both? No. Okay. And how many of you have advanced healthcare directives? Okay. Okay. Good. Well, so some of you have these planning techniques and some of you don't. And I always just like to know kind of where everybody is in their journey in planning before I get started, so then I can kind of tailor things. So I'm realizing I'm licensed in Florida and South Carolina. So I cannot give legal advice. Well, I can't give legal advice to you anyway, but I'm just saying, I have tried to make this presentation very generic, to kind of less to give you specifics about what statute or what product or whatever, but to kind of cause you to think of, okay, what is my plan, or do I need a plan, and what do I have and what do I need, that kind of thing. So so that's kind of where we're going to start. And we might, if we have time, maybe have a little discussion about, I know I'm going to talk a little bit about planning for, like, if you were to need institutional care when you're older, but we might go a little bit more into that if we have time. But that's a whole nother very long, complicated topic that we might touch on that. Let's go ahead and, so who needs an estate plan? Everybody. And I have to, true confessions, my will is 18 years old. Since I did my will, and I'm an attorney and I do this for a living. Since I made my will, I had another kid. We've sold a house, bought a house. My husband and I have had 3 or 4 different jobs. We have different retirement plans. So is it time for me to revisit it? Absolutely. And so just so you know, we're as bad as doctors who don't go to the doctor. But everybody needs one, and it's something that you need to start looking at earlier rather than later. And when I counsel clients on, because they'll say, well, you know, am I set? I'm like, well, you're set until there's a major life change, and then you need to look at it again. So I usually say every 3 years or so, think about it. It doesn't mean you have to change it, but just think about it. And then also if there's any major life change, birth of a child, death of a child, death of a parent, if you have like some kind of inheritance, divorce, death of a spouse, a marriage, you know, anything that's a major life change should cause you to think, okay, are my affairs in order, kind of thing. Okay. So the purpose of planning is so that somebody else doesn't tell us what to do after death. It's a big say in what happens to yourself. Okay. So loved ones, assets, that kind of thing. And it also reduces conflict. I have parents that are in their 80s, and I have an older sister, and she and I get along great. And we have told each other time and time again, we're not going to fight with each other over stuff. But I know in the back of my head, because I've seen this with families, that you can say that all the time. And then at the end of the day, when your parents are gone and emotions are running high, you know, there might be a conflict. And so a way to reduce that conflict is to have a plan. And the plan can be as simple, and I'm trying to get my mother to do this, you know, because usually you don't put every little bauble that you have, every little snow baby, every little ring, every little, you know, tchotchke that you have, you don't put that in your will. You can make an inventory. So what I tell my mom and I tell other people is get those little round stickers, put whoever you want to have it on the sticker, stick it up underneath the table or the chair, or the tchotchke or whatever. So anyway, that's just like a hot tip. So what's also great about planning is that it forces you to take inventory of your assets and also take inventory of who your decision makers are. A lot of what I do in my day job is talk to decision makers and some of them think they're decision makers and they legally aren't. So we kind of, walk through what that looks like. And then delegating decision making, either when you can't or when you're gone. So if you don't plan, the probate judge has a lot of control about what happens. And people that you don't want or don't know may be put in charge. So for example, you could potentially have a stranger serve as a personal representative if there's not anyone that's suitable. The legislature, now I don't want this to scare people. All this means is that there is usually a intestacy law. So the legislature has come up with that intestacy law. So I didn't want you to think that the legislature was actually deciding here, because they're not going to. But the intestacy law will determine where your stuff goes. Assets can end up with people that you don't expect or don't intend. That's especially important when you've got like maybe a special needs child or a special needs heir. They should not inherit directly because it could affect their benefits. Assets that can be distributed to your children before they're ready. If you've got minor children, that could cause all kinds of problems. There may have to be a trust that's created to manage that money until they reach the age of majority. And a 18-year-old, even if they're an adult, inheriting, let's say $500,000, is going to spend it differently than a 30-year-old inheriting $500,000. So, if you want it to be spent in a certain way, planning is the way to do that. Also, there's certain tax benefits and asset protection that you can do with a plan. And also privacy. That some of you raised your hand when you said that you had a trust, a living trust, or a revocable trust. That's sometimes used for privacy purposes in estate planning. And if you have a plan, like I said before, you don't have those disputes over assets. So that's why it's important. So we're going to talk about things that you'll see in a slide in a few minutes. There are things that you should do during life, and then things you should do that you should do in planning for after death. And most of the things that you're doing during life really have to do with your own decision making. And this is when you take anything away from today, it really should be that you need estate plan. You need a healthcare surrogate, a durable power of attorney, something like that. And they're called different things in different communities. So I will kind of talk about in a minute what those different things are. But anyway, so a plan can include a will, a revocable trust. Remember, I just told you that was an alternative to a will or used with a will, and it creates some privacy. A durable general power of attorney. And we'll talk a lot about what that entails, and you really need to trust the person you give the power to, but it can be a really great tool. Durable healthcare power of attorney. Also in Florida, we call it a healthcare surrogate designation. We like to do word salads in Florida, so it's healthcare surrogate designation form. Or living wills, which is another advanced directive that talks about end-of-life decisions. And a lot of those things can kind of work together. Also, beyond a will or a revocable trust, there are different things that you can do that, hey, Christina.
Hey there.
Oh, thank you. So retitling of assets, so kind of looking at, we all have payable on death type accounts, and we probably don't even think about it that way. Our bank accounts could have payable on death. If we have like a 401k or an IRA, they always have a beneficiary. Our life insurance has beneficiaries. So retitling of assets, whether it be real estate, there's different things that you can do to plan for the future. Now, if you do it in the wrong way, it could trigger some things, but that is an option. There are a lot of things that you can do that go beyond the will or go beyond the revocable trust. guardianship designations. With guardianship, we're talking about you can do a pre-need guardianship if you need a guardian. We have that form in Florida. It's just a sheet. It's just notarized. It's not like a big, it's not a big deal. But you can do a pre-need guardian for yourself. But you can also, if you have minor children or if you have an adult child with special needs, you can say in your will who you want to be the guardian. And I usually say do a primary and then an alternate. But just know that those are kind of like strong suggestions. And if, you get to court or your guardian gets to court, your proposed guardian, and the judge says, you're not eligible because of XYZ, or this other person wants to do it and is more suited, that can happen. But usually what happens is it's kind of like a strong presumption that the person that you designated as your guardian is going to be the guardian. Life insurance and irrevocable trust are also really good planning tools. And there's I'm not even going to go to all different kinds of life insurance, but a lot of times financial planners can offer you explanations of all the different benefits of the different kinds of life insurance and annuities and things that you can do for planning. Also, so there is not a one size fits all plan, but what I will say is you need to have documents that give people that you trust decision-making authority when you no longer have the ability to make decisions. So that's number one, whatever that may look like, okay? And number two, have some kind of will or trust that says where your stuff goes at the time of your death and who's going to take care of your loved ones that can't take care of themselves. So first thing is have some kind of documents that talk about decisions during your life when you can't. And then the second one is where your stuff goes so that your family won't fight over everything. Okay. So during life, all the documents that I talked about, the advanced healthcare directives, is really focusing on decision making. So there are different kinds of powers of attorney, and if you were to Google, we're talking about AI here, right? Just previously, if you were to do power of attorney, you're going to get like 30 different. You're probably going to get hundreds of different forms, and the problem is they are state specific in what the signing requirements, the notary requirements, the witnessing requirements. So I wouldn't necessarily leave this to just go to your local like Staples and get like a form thing or go online, or you definitely want to make sure that you comply with the formalities. That's what we call it in legal terms. The formalities is the signing and witnessing and notarizing. In every state, it's a little bit different. A general power of attorney means it has general financial powers. So most attorneys I know in the state of Florida kind of use a very similar form. We have this extra statute because they want to protect people, and they call them superpowers. But what that means is that the person signing it has to read it and initial it in addition to the signing. So like I said, every state's going to be a little bit different. You can have a limited power of attorney. I didn't do a slide on this because I just kind of want to say this is what you need for your plan. But a limited, I'll give you an example. A lot of times they're in real estate. Bart, you might be familiar with this because you're in real estate. I'll just give you an example. When my husband and I were first married and we're buying our first house, he was in the Navy and he was underway. And we had purchased the house, but the closing date just happened to be when he was going to be overseas. And so I drove up to, he gave me a limited power of attorney specifically for that real estate transaction. And so I took that limited power of attorney with me. And when I went through the hundreds of pages of documents, or at least it felt like that, I signed for myself as myself, and then I signed as his power of attorney. So I had to say, Sarah R. Sullivan for Jonathan B. Sullivan as his attorney in fact. That was fun signing like 30 times, but that is a limited power of attorney. And there can be other limited powers of attorney. So what durable means is durable, it comes into play immediately. So when you sign it, even if you have the ability to make your own decisions, it comes into play immediately, but it survives your incapacity. In Florida, we have a language that they put in the statute that says this language has to be in the power of attorney to make it durable. So whether it says durable power of attorney at the top of the form or just says general power of attorney, if it has that language in it, that the language basically is like, it survives incapacity, then you're good to go. And so the language they use in powers of attorney is the person you give the power to, the person that's going to be decision making, is called the attorney in fact. And they don't have to be an attorney, it could be anybody that is of legal age. And that gives people great flexibility in decision making. You don't have to go to court to do it. You don't, you just pick somebody that you trust and you give them the power. Now, with that great flexibility comes great responsibility. So you don't want to give it to somebody that you don't trust. Or if you give it to somebody and you trusted them at the time, but you no longer trust them, you should revoke that power of attorney. Prior to doing the job that I do right now, I did some elder law work, and I more often than not would get the bad kid, the bad adult child who was misusing the power of attorney, kind of raiding the coffers of the client, and we were trying to really protect the elder person from this this adult child. So you definitely have to trust who you're giving the power to. I also recommend doing an alternate because you never know when, that person could predecease you. They could be unavailable at the time that you need them to make a decision. And so it's important that you do that. Now, you can, in Florida, the power of attorney becomes effective immediately, whether you want that person to make decisions for you or not. And let's see. So when you are, people will come to me and say, well, I don't want to do this now because I'm afraid that when that they may use it and I don't want them to use it now. What I usually tell people do in that situation is you just say, this is what my parents do, because they really don't want me involved in their finances right now. They can do it themselves, but they want me to be there in the event that I need to be, is that they have copies of it in their they have like a lockbox. And so I've seen it when it was drafted and signed, and I know it's in the lockbox, and I know that if I need it, I go get it. A safety deposit box, whatever. My former boss, she tells funny stories about her mother. Her mother was so untrusting of everybody, including her children, that she kept her powers of attorney at her attorney's office, and they had to go to the attorney, and the attorney had to make an assessment on whether or not they could have them. And I'm like, that's extra for sure. So you don't have to go to those lengths, but you don't necessarily have to give the document to the person you're giving the power to immediately either. So if you want them just to use it when you're incapacitated or when you want them to use it, you can keep those back. Okay. Let's see. Oh, powers of attorney can have healthcare powers in them. The form that I generally use does have on the bottom that if there's not a healthcare surrogate or designation of healthcare surrogate, you can, that basically the durable power of attorney acts as a healthcare surrogate. Let's see. So the healthcare surrogate designation, also called a medical power of attorney in some places, it appoints someone to make healthcare decisions. This is the one that I think is the most important of all. I have had so many cases where somebody has fallen ill, or somebody is completely incapacitated in hospital, and they may even have a will, right? They may know where their stuff is going when they die, but during life, they have not designated anyone to make decisions for them in a healthcare emergency. So a healthcare surrogate is a great way to do this. And the healthcare surrogate can have a couple of different components. It can name the surrogate is the person, right? They can name a person and an alternate. You can also say that they have access to your health records immediately, or you can say not until I am no longer to make those decisions. It can have a HIPAA release within it. So there is some flexibility in what you put into the healthcare surrogate designation. But again, like I said, it is so important to have this document. When you go to the hospital, usually they'll ask you if you have one. Some proactive hospitals may even have like an administration or social work office where they might have forms for you to sign, which I think is great. But this not only makes it easier for your loved ones to know who's making decisions, it's better for the hospital too. So I literally had a case where the ethics administration, they have like an ethics panel, and there was this big debate on what to do about a woman who was a client, and her daughter was not capable of making decisions, and her closest relative was in Egypt and could not get a visa to get to the United States fast enough. So it was really sad because people wanted to make decisions, but there's nobody had legal authority. So that's why this kind of thing is, and the hospital can make a decision, like in our state, and I think in many states, they kind of have a proxy statute, which says that in the event that there's not someone to make decisions, then it kind of follows this list of priority. But you don't want to go there, right? You want to be able to say, this is who I want to make decisions. When I was in South Carolina, my paralegal had worked with the firm for decades. And it's interesting, she trusted the people in her office more than she trusted their family members, because they were her healthcare surrogate. Because I don't know why, I guess she thought her kids would be too emotional, or wouldn't follow through on her wishes. But so it doesn't have to be family, it doesn't have to be children, adult children, it doesn't have to be brothers, sisters, spouses, be anybody you want. And that's what's great, is because you get to choose rather than going through a guardianship proceeding and that guardian making the decision for you. Okay. So living will. A lot of times people get the living will and the healthcare surrogate confused, or they get the living will and a last will and testament confused. A living will talks about end-of-life decisions only. It is a healthcare advanced directive, but it is talking about end-of-life decisions. So the three conditions, terminal condition, persistently unconscious, or end-stage condition, you have to have one of the three. In Florida, your treating physician and a second physician have to certify that not only do you have one of these three, but basically end of life is imminent or near. And then in a living will, you tell them whether or not you want to have, do you want to have extraordinary, means or treatment, meaning to keep you alive no matter what, or do you want to have palliative care and be taken off life support. You can really kind of fashion what you want and don't want in your end of life care. How many of you remember the Terry Schiavo case? Some of you may be too young for this, but I would say probably it was early 2000s, probably late 90s or early 2000s. There was a case, Karen, you remember that case? Yeah. So it was a heart-wrenching case, and it was actually it originated out of Florida. Yeah, Jim, you remember that case too? Yeah. So basically, what happened? There was a young couple. They had been married. There were not advanced healthcare directives. there was some kind of accident, and the wife was put on life support and was kept on life support. And the litigation was between the parents of that young woman and her husband. And there was a lot of question as to whether or not her telling her husband what she wanted, which was to not be left on machines for the rest of her life. And she did not want extraordinary measures. She wanted to be taken off life support. So he testified, that's what she told me. And the parent said, well, that's not how we raised her, or that's not, I'm simplifying things. So basically it's several decades of litigation, and she was on life support. And it went all the way to the Florida Supreme Court, then to the United States Supreme Court, and then back. And had she had a living will that basically said, I don't want extraordinary measures at the end of my life. I want, if I cannot sustain life myself, I want life support not to be implemented. Had she had this, it wouldn't have been an issue. And I really think that the living will, I know that at least from the Florida bar perspective, once that case happened, they started making this form kind of available to anybody that wanted it in Florida. They were like, you don't need to go to an attorney for this. Like, here's what the form is. And I think even the Department of Health or Department of Elder Affairs has this available. And it can go along with a healthcare surrogate. Usually it does name a decision maker and an alternate, very similar to the healthcare surrogate. So it's probably important to have those be the same people. I've seen some attorneys do it where it's the same form, where they do the healthcare surrogate stuff and then they do the living will. Some of you may ask, what is the difference between a living will and a healthcare surrogate? A healthcare surrogate is the who. So you're telling someone to make any decision for you. And the living will is very more specific to what. So even though it names a person to make that decision, they're really just making sure that the doctors do what you've already told the doctors to do. The healthcare surrogate tends to be of a broader application because you don't have to have a terminal condition, a persistent unconscious end-stage condition. Let me give you a scenario. Let's say you're in a car accident and you are at, let's say you're in the ICU, and they suspect that you're going to make a full recovery. So you're not in one of these three categories, but you need, let's say, a blood transfusion, and they don't want to give you one unless they've got someone to say that that's okay. But you're unconscious. So they would go to your healthcare surrogate and say, would you please agree to the blood transfusion? The living will doesn't really come into play here because it's not the end of life. It is a place, though, where they do need a decision maker to make that decision for care. I have another colleague who is a fantastic elder lawyer in Gainesville, and she was doing a presentation for us about the use of healthcare surrogates. And she said, my mom is just tired of dealing with her healthcare, and she's able to do it, but I am now her surrogate, so I can intervene, I can talk for her, I can make her appointments, I can go get her prescription drugs, I can do these things for her as her surrogate, even though she still has the ability to do it. So it really has this really broad application. And the reason I'm spending so much time on it is because I feel so strongly that everybody needs to have one. If you have nothing, have a healthcare surrogate. If you feel strongly about end of life decisions, have a living will. Okay. I'm going to get off my soapbox now.
Before you get off your soapbox, can you go back to the last slide?
Sure.
So, I'm married,
and this is
no kids.
Okay.
So in that case, if I am all of a sudden in an accident and in a coma, would my husband, as my spouse, be able to make decisions of what to do with my health care?
So this might be kind of a state by state situation, and there's also there's what's in theory, and then there's what's in practice.
Right.
But so So I will tell you that, for example, and I was mentioning that proxy statute that kind of lists when there's no decision making at all, they have that proxy list of who is in priority.
Right.
Spouse is number one, right?
Okay.
So spouse is number one. So it's the kind of thing where they probably would let the spouse make decisions. I guess the thing would be, so I'll give you an example. My mom, if my mom goes to the hospital, my dad's not able to accompany her.
Right.
And even though he's probably the most appropriate person to make decisions for her, he just can't physically be there.
Right.
So I'm there, but if I were there and I didn't have the healthcare surrogate, I could not speak for my mother.
Right.
But I will tell you, in practice, in the hospital, they're probably like, spouse is fine. You know, they're not going to question it. And usually what happens, we have not necessarily had to produce a document so much as, and I think it depends on what it is too. Like, for example, yesterday I called my mom was like flustered about some doctor's appointment. And I said, well, let me just call the doctor's office. I was just calling about changing an appointment. I did announce myself as the healthcare surrogate for my mother. Maybe they had it in their chart somewhere, I don't know, but they didn't question it. But I wasn't telling them about whether or not to do a blood transfusion. It was like, hey, can we make this on Tuesday instead of Friday? Right. So I think when they start getting into those kind of really heavy duty medical decisions, having the planning is the best way to do it. Right. Okay. So, and I should say, and this may have been your question all along, if you want your husband to be the decision maker, make him the primary, and then make whoever you want to be your alternate. Also, a lot of people don't want to offend their kids or their relatives. And I'm like, this is about who's the most appropriate person to make a healthcare decision. And I know I'm using a lot of personal examples, but that's how I teach. So anyway, my sister is out of state. My parents live here close to me, and I'm an attorney. My sister tends to get emotional and hasn't been around for the whole healthcare journey, right? So she comes in when there's big stuff, but she hasn't lived through it. So I'm the alternate, and not my sister. And there were times when my mom said, well, should I just have both of you? And I said, I can't tell you because I can't be your attorney, but I'm like, look, this isn't about offending my sister. This is about what is most practical and what you want about decision making. You've discussed with me what you want. I know what you want. I'm here. It makes more sense. But I'm not going to tell you who you can and can't have. So it's people will say, well, I want everyone to feel loved, or I want everyone to feel equal. And I'm like, no, this is about medical decisions. So you do what's best for you. Yeah.
Okay. So, and then another question. So I'm in a similar situation as you are with elderly parents, and it's my mom and my mother-in-law, both in this area. And my husband is an only child. So he is power of attorney. My mother-in-law did sign that paperwork, and wanted him to take care of decisions because she was starting to have signs of dementia and is very far gone now. With that power of attorney, and at one point he had signed the paperwork for healthcare related power of attorney, and she named him as first, me as second, and one of her nieces as third. Don't know that her current doctor is following that. But with or without, well, if that is not actually in place, would the power of attorney supersede or take precedent or be enough to cover any of these decisions related to healthcare or end of life decisions?
And I think it really depends. And gosh, it sounds like such a lawyer thing. It depends. That's what we like to say. It depends.
Right.
Yeah, but it really depends on how the you remember when I said before that with my power of attorney, which is mostly I would say like 99.9% financial decisions. And
Yeah.
then at the end, I have a little thing at the bottom that says, like, you know, if there's no other thing, there's, you know, this serves as healthcare. So it
Okay.
really just depends on what's in that power of attorney.
Yeah.
And if you can find a copy of that medical paperwork, if there's nothing showing that it's been revoked, it should still be
No.
valid.
Okay.
Yeah. So, and that's sometimes it's just a matter of presenting it to. That's another thing. When you have these documents, you can keep them in your little lockbox, but you can also give them to your primary care provider. You can give them to the power of attorney to your bank.
Yeah, we've given
all those
copies to the assisted living facility where she lives and some other folks. So, okay. Awesome. I appreciate it. Thank you.
But it's, oh no, and but I also encourage you to, because I think you're in another state, to run it if you want to run it. If it becomes a concern, definitely just set up an appointment with an attorney. They're usually very glad to look over what you have, and kind of tell you. I actually have friends where we'll have families that come in from out of state, and they'll have all their planning documents from, like, you know, Virginia, and they'll say, well, is this good? And I'm like, I can't, I mean, I can look at it, but I can't tell you. So I send them over to a colleague, and they look through it, and they're like, oh no, this is good. Or, oh no, we need to do, you know, something. So yeah, I encourage you to do that.
Absolutely. I appreciate that. Thank you.
Oh, no problem. No problem. So after death, which I felt like I should have like a Darth Vader image here or something, because it sounds so dark and foreboding. But when you're doing, I'm gonna go back, because I meant to say this. Healthcare surrogates, powers of attorney, anything that is decision making during life ends when you pass away. So a power of attorney, if you have a power of attorney, once you die, that person cannot make decisions for you anymore, because it goes to a whole nother thing. And that's important, because people will be power of attorney and they'll call me up and say, well, my mom died, but now I can't get into the bank. And I'm like, yeah, because she's dead. And the power of attorney dies with the you know. So so that's where some of this other planning can help. The trust kind of helps with that, or if you have a personal representative or executor named in the will. So if you do a payable on death designation, or name a beneficiary, that beneficiary can work with either the insurance company or the management company or whatever. So I just want you to, a lot of times people are frustrated that, oh, this person helped me do all these financial things during my life, and now you mean they're not going to be able to pay my mortgage? And I'll be like, no, but you might want to set it up on auto pay, until, because that'll help, right? So there are all kinds of ways to get things done, and sometimes there are several paths to get to the one destination. So where there is no will, I mentioned this before, it's called intestacy. Intestacy, every state has statutes on where stuff goes if there's no will. And when I mentioned before the legislature decides, that's what I meant, is that there's a law that says if somebody dies without a will, it goes to this person, then this person, and this person. And it goes through a whole list of how they determine who gets it. And you think, oh, well, that makes sense. Well, imagine the blended families of today. It gets interesting. So let's say you've got somebody that's married 3 times and they have children with 2 of them, but not with the last one. And then they die without a will. And then there's some kids that are kids and some kids that are adults. You know how you handle all that? You do a will, so that you don't have to worry about intestacy. I had a really sad case. I had this, she had been a niece of somebody, and she had spent the last 5 years taking care of this gentleman and living in his house. And it was a very humble place, but one of the things was, hey, you can have my house when I die. He did a will that was typed. He signed it, and it was witnessed and was notarized. But in Florida, you need 2 witnesses, and this one only had 1. So the will was invalid, which meant his property went by intestacy. He had 12 siblings. Those siblings had children, and some of them were half, anyway. So all those siblings had children. So there were all these nieces and nephews. And in order for her to get the house, all of those people would have to give up their share in the estate. So that's why estate planning is so important, because if you die without a will, and especially if you have a blended family or if you have a large family, you definitely want to be able to say before you die where your things are going to go. And you don't have to have a huge estate to justify having this. So no named beneficiaries. So you don't really have control over who's going to get it. Let's say you need a guardian over a minor child. You haven't, put forward who that's going to be. There's no testamentary trust. It's just kind of a mess. Now, some people may have a simple family tree, and it's going to go to the spouse and then go to the adult children, and everyone's going to be fine. But in most cases, that's not the case. Bertina, did you have a question?
Yes, ma'am. Hi, Sarah. Hi, all.
Hi.
I also wanted to say, having gone through that with when my dad passed, my mom passed before him, and my dad passed, and I had a will. Being the only child, I thought, okay, everything is good. But then I found out that even with a will in Florida, if you don't have, that in hand, like a life estate, or something that specifically says that the house is going to you, even if the house is willed to you in the will, it does not suffice in Florida, and I think maybe even Georgia. So, I know that now, and I'm looking to do that to make sure my kids are on the deed. But I didn't have it before my father passed, and found out that, yeah, even with the military will, it wasn't enough.
Well, and that's a good point. We're going to talk about that in a couple of slides. But if there is property that passes outside of the will or outside of the probate estate, and even if it's like you said, if it's and Bart, you're going to like this because you're in real estate. So if it's a joint tenancy with right of survivorship, both people on that deed have 100% ownership, and when the first person passes, it passes automatically to the other person 100%. So so the will, even if the will gives you the house, it's not yours to have because it's already gone to the other person if it's a joint tenancy. So I think that's probably, I don't know the particulars of your situation, but I'm imagining that that's probably what happened. Is it had a lot to do with how the deed was titled and registered. And so with also with military, the military does a really good job of like helping with powers of attorney and wills and things like that. But they're not always state specific. So it's important for somebody that, and like I said, I always think it's fantastic. They are really good about, before somebody goes on deployment or goes overseas or whatever, does tours, they're really good about getting their advanced healthcare directives and powers of attorney and wills done. But when they come back and they start building up assets, they probably need to revisit those and make sure that they are in the state where they're living are good about that. So thank you, Christina, for bringing that up, because we're going to talk about that in a minute. We're going to talk about wills first, and then
wonderful one. Yeah. I did want to note that the only two people who were on the deed was my mom and my dad. My mom passed before my dad, so it just left my dad. And so they said that I still would have had to have a ladybird deed or have it filed in the court before my dad passed. Yeah. And so I ended up having to, although there was no one to contest it, I ended up paying a lawyer for probate.
Yeah. Well, reach out to me later and we can have a further discussion about that, because I'm always curious about how all that, how that works out. So, but thank you. Thank you for bringing that up.
If I can ask a question, I apologize for interrupting. When you are, say you remarry and you are changing beneficiary from one spouse, from a former spouse to another, what exactly will be the process, and the importance of how quickly you should do it?
So when you go through the divorce, you should revisit your estate plan at that point, for sure. If you by chance don't revisit your estate plan, you should definitely do it when you get remarried. So as quickly as possible, and but not only do a will or look at your deeds and how they're titled, but also look at your life insurance beneficiary designations, your retirement, even if it's done through your employer. I know that, for example, let's say, like right now with my employer, I've had the same beneficiaries for as long as I've been there, and they automatically just kind of go on from year to year. I don't have to redesignate every year. And if you've done that, for example, or if you've had a life insurance policy for years, you may still have the X on that designation. Now with real estate, and I'm going to bring in my, I need Eddie in here. He can give us his expert divorce advice on deeds and real property and stuff. But a lot of times the dissolution of marriage will, like the final judgment, the divorce judgment will have specifically how it's supposed to be done, and you know, how long you have to, you know, pay the other person or get the deed or do a quitclaim deed or that kind of thing. So obviously it's not just a will, or it's not just changing a deed. If you've been through a divorce and you have that final judgment, it usually does instruct you on like what to do. But after that, you should definitely seek out a estate planning attorney or an elder law attorney and kind of figure out what to do. And I hate to say, hey, you need a new estate plan when you get divorced, and you need a new estate plan when you get remarried, but those are two major life changes, and that beneficiary might change. Like, for example, once you get divorced, you may want your kids to have everything, or maybe you want your parents to have something, or your brother to have something, and then you get remarried and maybe you want your new spouse to have everything. So you should do it as quickly as possible, but not just look at the will, look at everything. Also, if you have a prenuptial agreement, that prenuptial agreement can also be kind of a planning tool, because that might also talk about if you get divorced, how things are going to be titled. So there's a lot of different moving parts. And my advice to you would be, because there are so many different moving parts, is that when there is a major life change, like a remarriage, is you absolutely, if you know what you want, you know what you want, then you go and to your estate planning attorney and say, this is how I need to have things done. And make sure, if you do a will, it replaces the previous will, okay? And when you do a deed, you obviously have to register it in order for it to be enforceable. But for example, if you have a final judgment that says that you have to keep both husband and wife, ex-husband, ex-wife on the deed, you can't just go and say, well, I really want my new wife to have that. Won't work that way. But anyway, so different moving parts, but definitely take maybe the dissolution or the divorce judgment, and you know, if you have a prenuptial or whatever you have, to the estate planning attorney, and definitely work it out, but sooner rather than later. Okay. And I hate to say this, but if you get divorced again, you need to have another estate plan. So it's one of the, anytime you have a major change that's going to affect the way that that property is going to be distributed, is when you need to consult with somebody.
Thank you.
Okay. And I know you're probably like, cha-ching, that's a lot of attorney fees. I'm not. I'm one of the attorneys that if some third party would pay me, I would get free legal advice for the rest of my life. But sometimes it's really, really important to have those things. Vito, I see you there. You have a question?
Yeah, me and my brother, we both live ironically on two different sides of the country. Like, he's touching one ocean, I'm touching the other one. And our dad lives in the Midwest. And we've kind of, like, what advice would you give for us living in two very separate locations, never really going back home, trying to talk to our dad and help plan out for his ultimate, you know, demise? Because my dad doesn't have much to our knowledge. even though we secretly say he might be a billionaire because he just doesn't tell us anything and he lives so frugally, and we know he's not rich, but we know how much he makes and it's not nothing. So it's like, how what advice do you have for like going about trying to set up a power of attorney, getting him to set up the will and, do all of
Right.
it, since he's up there in age and just doesn't really, we kind of don't want to walk into it blindly, but we could get the unfortunate call today and we both be like, so where do we start with
We don't know, right? So that's tricky because he has the ability to make those decisions, and he's the one that's doing the power of attorney, and he's the one that's doing the will, and you're kind of saying, hey, help me help you. That's what I'm hearing from you.
Yeah, like he knows what he wants.
Is,
like he knows where he wants things to go. He knows, like, we wouldn't be fighting with him about it, but he's like, I've never had to deal with lawyers before, so I don't know how to do it. And we're like, we don't know either. So it's like the three students, like, we know what we want, but we do not know how to get this started.
Yeah. What I would definitely do is probably find an elder law attorney, because I think that they're probably more equipped if he's older, and I say 60 or older. There are some other things that they might be looking at for him for planning purposes. But definitely, maybe you and your brother should find a time where you, go to see your dad in the middle of the United States. Before you go, kind of find a couple of attorneys and just kind of have a conversation with them, like, hey, we want to live out your wishes, and there may be a time when you can't make those decisions. And if that's the case, we want to help out, but we need to know what you want. We respect your privacy, we respect your desires, but if it's in writing, we have a better chance of fulfilling what you want. Do it that way diplomatically, and that's probably the best case, but definitely go see somebody. Like my mother-in-law, there's this really great nonprofit up, she's in Massachusetts area, there's a really great nonprofit that helps seniors, and it's kind of a multidisciplinary place, and they do have a estate planning attorney that kind of works with them on a kind of a low bono, but they also helped her, advise her on, like, do you need a reverse mortgage or not, or are they bad, or are they good, and what's your situation and what assets do you have, and that kind of thing. So they had a financial planner, social worker, attorney. It was great. So maybe if they had a similar, I don't know where he lives, but if they have something like that, every major city has a council on aging. It comes federally, and then they fund the states, and the states have them in different communities. So offline, and Vito, I know you have my information, so reach out to me and I can help you find that council on aging, and that they may also be able to help because they also have caregiver support.
Understood.
I am running out of time. Oh yeah, I'm running out of time, so I'm going to run through this really quick, and then I will take any questions if we have any more. Okay, so guardianship over loved ones. If you have a durable power of attorney and a healthcare surrogate, you are going to avoid guardianship. Guardianship is you have to file in court. It is a lawsuit. You have to hire an attorney. You may have to pay for a professional guardian. If you want to avoid all that nonsense, you do your advanced planning. So remember, when I'm so emotional and so like on my soapbox about these things, this is why. Because I've done guardianship work, and guardianship is for people that are incapacitated and can't make decisions and haven't done their advanced planning. So somebody has to be appointed by the court, and then the court looks at all your financials, and the court looks at all your plans, and it's very intrusive, but it's required. It's very necessary for people that don't have decision makers. So if you don't want someone else making your decisions, power of attorney, healthcare surrogate. Like I said before, if you have disabled children, you can, or if you have minor children, you can pre-designate guardians for them in your last will and testament. That is a kind of a presumption, but not a certainty. And those people have to file the appropriate paperwork to become guardian over those people. But like I said, it's very important for you to avoid it if you can, but also have that pre-need guardian form that can be part of your estate plan that basically says, if I become incapacitated and I need a guardian, this is who I want it to be. You can do that and a power of attorney. And the reason you do that is if one of them fails, you got to back up. So, okay, living trust. This is another form of estate planning, and I'm not. This is, and what I can make these this PowerPoint available to all of you because I know I'm going to kind of fly through the last several slides. But sometimes a living trust or revocable trust is a way to put all of your assets into it, and it the big thing is that it avoids probate, or at least a lot of the stuff will pass outside of the probate estate because you put it into the trust. So it's kind of like doing your probate in this trust document before you pass away. So it kind of goes on it names trustees, and it names like how things get distributed at the time of your death. So it can be really effective. It also you can kind of direct how things are spent or distributed. So if there's somebody that is, maybe if you gave them $1, they'd spend 10. A trust is kind of a great way of having a little bit more control over how they spend it after your death, rather than them just getting it outright. Also, if you have a disabled child, you can create a special needs trust within the revocable trust. And what happens is the trust funds the special needs trust at the time of death, and then you've got your child who's inheriting, but they're inheriting it through the special needs trust, and they stay eligible for their benefits. A lot of times people may have a will that has a trust in it. That's called a pour over will. And it's for assets that weren't transferred into the trust at the time of death. So sometimes people will have a will and they will have a living trust, and the will is just kind of like a safeguard to make sure everything goes into that trust. Okay. By the way, there's like so many different trusts. So if somebody says, "Oh, I got a trust," well, great. What kind is it? What's it for? What's the purpose? What are you trying to achieve? And so that's important to talk with your planners, because there's definitely different kinds. I think I just mentioned like 3 different kinds in the last slide. So be aware of that. Not all trusts are the same. So revocable trust, like here's some of this is a nice chart that kind of talks about, hey Eddie, I know I know I'm running out of time. I'm trying really hard. But anyway, so here are some benefits, and kind of what a revocable trust does versus a will. Some of them do both things, but I'm just gonna let that chart go there. And then knowing the difference between what's a trustee and a beneficiary. Sometimes they can be one and the same person, but they may have different roles, depending on whether or not you have a revocable trust, special needs trust, or a last will and testament. Okay. And then who are you going to provide for and how much? These are the decisions that you make in your will or in your revocable trust. It could be children, charities, other family members, special needs adult children. But as we've already kind of discussed, how that money is given, whether it be outright or whether it be, you can really do whatever you want. You can get creative with your will or with your trust about how it's distributed. So, for example, you don't have to give everything outright to your 25-year-old. You could say, I give you $100,000 when you're 25, $100,000 when you're 30, down the road. So that's what's kind of nice about advanced planning, is that you have way more control. And I think we kind of already talked about it, but definitely with your life insurance, your retirement, your IRAs, your anything, payable on death accounts, anything that has a beneficiary. Even if you're at work and you've got that $10,000 life insurance, check your beneficiaries regularly. Just like you look at your estate plan, your will, look at your beneficiary designation, because these things pass automatically. We were talking about, I was talking to Bart about having that, how a house is usually titled between husband and wife, or spouses, is that it's usually joint tenancy with right of survivorship, which means that once one person passes, 100% goes to the other, and that goes outside of the probate estate. So pay attention to how things are deeded, pay attention to how things are, which beneficiaries are designated, okay? Eddie, how am I doing? How much time do I have? No time.
I think you're about up.
Yeah. You basically
reached the end of the time, essentially.
The only thing I would do right now would be to quickly wrap it up and share your email to the chat so that anybody who has any further questions or who have any information that are a bit more personal and they want to share in the session, they can give it to you. And then I'm going to add my email so that if you're willing to send the PowerPoint presentation, I'm pretty sure everybody will have some sort of value out of it. Definitely. I know I do.
Yep.
And I know that I will definitely have to go through it because part of the estate that I stand to inherit is also overseas. So that's a whole other can of worms.
Mm-hmm. Absolutely. So Vito also put in the chat 5 wishes. That's amazing. That popped into my head during my presentation, but I didn't actually verbalize it. But that is also a great way to talk to family members about planning without it being over the top or you must do this. So 5 wishes, everybody should look at it. It's kind of a nice, easy way, entree into making decisions for people, and highly recommend it. So just kind of in wrap up, I think the biggest theme would be protect your children, protect your loved ones, plan, create decision makers, revisit your estate plan, and in your estate plan, include all those things that have beneficiaries or payable on death kind of designations. And then I know we're out of time, but does anybody have any questions? No? Let me look through.
Your email, you said, right, to ask any questions?
Yes, email if you have any further questions, but realize I am only licensed in the state of Florida, and I always encourage you very highly to go to an estate planning attorney. Miami? Okay.
Thank you.
And I probably, either between Eddie and me, we can set you up with somebody that's really, really awesome.
Thank you.
Awesome.
Okay. Thank you, everyone. Sorry I didn't get through the whole presentation, but hopefully you got a little bit of something out of what we talked about.
I know I got everything out of it because I had absolutely no idea how estate planning works in the US.
Okay, great. Thank you,
This
everybody.
was immensely helpful. Thank you, Sarah.
Okay, good.
Thank you.
Awesome. Great. Okay, bye. Thank you.
Bye-bye.
Good.